Every single reauthorization of the Voting Rights Act, Section 5, was signed into law by a Republican president. And so in 1970, the reauthorization was signed into law by President Richard Nixon. In 1975, it was President Gerald Ford. 1982, it was Ronald Reagan. And in 2006, it was George Bush. It was the current House majority, held in different form, but when Republicans in charge of the chamber who allowed the reauthorization to move forward through the Judiciary Committee on a bipartisan basis. Now, this may seem strange in the current poisonous environment of Washington that we exist in right now, but there was significant cooperation, tremendous leadership shown by the then chairperson and the ranking member, John Conyers. It passed in the House of Representatives 390 to 33. It's also interesting to note historically that prior to this year, every time Section 5 and the Voting Rights Act has been used to address alleged concerns with redistricting, which traditionally take place 2 years after the completion of the census, when it was used by the Justice Department to block or modify redistricting reforms or changes prior to the Obama administration, every other occasion since the passage of the Voting Rights Act in 1965, it was a Republican Justice Department charged with the responsibility of addressing concerns with redistricting and the problem of racial gerrymandering. It was the Nixon Justice Department in 1972. It was the Reagan Justice Department in 1982. It was the George H.W. Bush Justice Department in 1992. It was the George W. Bush Justice Department in 2002. And so the history of Section 5 and the Voting Rights Act is a glorious one, not just as it relates to the preservation of our democracy, addressing the need to make sure that every American, regardless of race or color, has the capacity to participate in a meaningful way, but it's been traditionally viewed and executed through a bipartisan lens. And we're hopeful that when the Supreme Court takes up oral argument on this matter in 2 days, that they will evaluate it on the merits and give due deference to Congress, which has consistently reauthorized it pursuant to its power under Article 1 of the Constitution, as well as the 15th Amendment to the Constitution of the United States of America. There really is no case to be made that it should be declared invalid. I believe we've illustrated time after time how it's been used to protect the integrity of our democracy, and we're hopeful that at some point down the road it will no longer be necessary. But, Mr. Speaker, that moment has not arrived in America as of today. I yield back